the hearing sessions. Just give a second for people to log back in. Just quick points before we get into the discussion proper. Thank you to the council for circulating that note on the number of units that would be envisaged to discharge to the Camberley sewage treatment works. I've received that and I've asked for it to be circulated. Have people received that note in the room? Or has it just come to me so far?
No, I haven't.
It's it's just being sent as we speak, really.
Okay, I think I only sent an email to Ian a few minutes ago, so it's my delay there. I mean, in headline terms, it shows 1,479 dwellings currently unconsented that would discharge the Camberley sewage treatment works. I'll wait for that to come in, for people to open it and to have the chance just to look at it. It's just a single table. I think in terms of what would be useful for publishing as an examination document, Mr. Bartlett, before you referred to similar figures for light water. I think for completeness, if the table for light water could be added to this document, and then that could be published on the examination website, that would be helpful from my perspective. And as you indicated before, the numbers for light water are much lower, and you indicated that those are all, I think, entirely either the 6 to 10 or the 11 to 15. But nonetheless, for completeness, I think the equivalent table for light water would be of assistance. If that could be added and then the document published, I'd be grateful. Thank you.
I'm very happy to do that, sir.
Okay. Have people received the has it come through to people's respective inboxes?
It has to mine, yes, thank you.
Yes, just come through.
It's arrived, sir.
I've got it, sir.
Okay, perfect. Thank you. Does anyone have anything they wish to say about the document? Okay. I'm happy if people are still digesting it. I'm happy for a hand to be raised in a short while. So if anyone does wish to come in, then just use the raise hand function on the toolbar. The other point we left from before the break was the points that we were pursuing with Mr. Koloff with regards to a note about whether there would be a cut-off point or a threshold at which a portcullis might come down. So, for example, at what point would Thames Water be seeking for ground puking conditions to be applied to new consents to prevent occupation prior to works being undertaken? I've reflected on that over the lunch break, and I was reflecting on something you said, Mr. Koloff, that whether the impact of a scheme isn't necessarily a pure numbers game, so to speak. You made the distinction between a greenfield site and a brownfield site, for example, and a brownfield site might already have a number of connections to the network and might already generate an amount of discharge, and then that would need to be considered in Thames Water's response. Is that a correct understanding or a correct remembering of what you said?
Yeah, I think that's a fair reflection on it. So yeah, like you say, greenfield sites may be entirely new flows to a works, whereas if you've got existing brownfield sites, there'll likely be a degree of flows that they'll be already going to the works. There may be potential source of surface water going to those works as well, which could be potentially resolved through redevelopment as well. So there is more opportunity with brownfield sites.
Okay, that's helpful clarification. Thank you. I mean, it just occurred to me that when I was thinking this through, that it's a question for you in the first instance, Mr. Koloff, but it occurred to me, firstly, that if the lion's share of the development which will discharge to Camberley wastewater treatment works are brownfield sites, and we talked before about the London Road block, which is over 500 dwellings, the station site, which is in the region of 200, and the Knoll Road site as well. The three big sites in the town centre would be in the ballpark of 1,000 dwellings. Each of those has existing uses on them, multiple uses in some cases. So in that situation, would it be more of a case-by-case assessment rather than a kind of numbers assessment?
I think it would be, yes, and certainly where we have redevelopment proposals, there is potentially opportunity for phasing plans as well. So it might be that you could have agreements of phased development. So, for example, the first 100 homes could be occupied, but then we have got concerns beyond that point. So again, it could be staggered to align with the with upgrades that are in the process of being delivered.
So given that we're largely talking about existing brownfield sites with existing uses on them, whether that's offices, the train station site, or at the Knoll Road site, or a mix of retail and some residential and other uses at the London Road site, would you be able to give me a simple note in principle that set out where any threshold might be, or is it too dependent on individual?
I think it is going to be very challenging just due to those, like you said, the circumstances for each individual case are going to be different. So it will depend on those existing uses, what their discharges are, any sort of surface water connections there may be, and then obviously the net increase or the quantity of new development. Again, the impact of new development is like I think Mr. Beckerson was saying earlier, obviously with higher water efficiency standards, that reduces the net impact of that new development as well. But effectively, we need to review the impacts of each application. But there's less likely to be concerns for brownfield sites than for greenfield sites.
And would you need to have a planning application before you to reach a kind of informed view on those sorts of matters? Would you need more detail than just a red line boundary, for example?
More than likely, yes. I don't get directly involved in that side of the business in terms of responding to the applications, but obviously the more information we have about development, the overall quantum of development where it's connecting to networks, more of a network issue. But yeah, the more information you have about the final development, the better it is for them making that assessment of what the impacts on the infrastructure will be.
Okay. Mr. Barron, your hand went up first. Do you wish to come in?
So yeah, it's just a quick question about the supply figures that have just been put through in terms of the Camberley Town Centre and the impact. It's 0 to 5 and 6 to 10, but I was just wondering if the council could say when the 0 to 5 is that from adoption, so it's for the first 5 years from adoption with regard to those figures, or just what the timeframes are with regard to those periods are. So just it's important because of the nature of the sites. I think as Mr. Koloff has said, in terms of when certain sites are coming forward and when they might deliver and how many homes they might deliver up until that 32 period and beyond. So I think it'd be important in terms of knowing when those sites are relevant to the delivery in terms of the supply. So the specific timeframes with regard to those. We've obviously got the overarching, just these singular figures, but obviously it's about those specific sites and when they would come through, just as you've said, sir, in terms of the 1,000 homes and how they relate in terms of the phasing. And I just that would be helpful, sir.
Thank you, Mr. Barron. I think that's a fair point about the phasing. I mean, perhaps in the final version of this table, I mean, point of clarification for the council to answer first. But then moving on from that, it might be helpful in the final version if those, rather than saying 0 to 5, 6 to 10, etc., it says the actual years that are being assumed. But if the council could answer that orally first, I'd appreciate that. And you indicate you wish to come in as well.
So it's based on the SLA 2025. So it isn't 5 years from adoption because we've looked at the plan period as a whole. So it goes up to the 0 to 5 years, it goes up to 2930. And then the subsequent 5 years goes up to 2034, 35. But we're very happy to provide it on an annual basis. It's that's something we can do so that you can see it for each year. If that would be helpful. It's with more time that would be easier to do.
I think an annual basis would be helpful, actually. I appreciate it's going to become a less simple and a neat table, but that would be helpful for me in terms of understanding or the numbers of dwellings that are coming forward over what time frame, particularly given there's a fairly specific point in which these upgrades are going to be available. Did the council wish to say anything else? Because its hand went up before I put that point to it.
Yes, so it was just to give a bit of background on each of the sites, because I do think that is important, noting the brownfield element. So Land East Knoll Road for 340 units already has the council offices currently on that site and the library. In terms of the station site, you have the station itself, but also an office block that was previously used by Accent Housing, and then London Roadblock itself has a number of existing uses that will be feeding into the current system. It's also worth noting, I think quite key, is that London Roadblock is split over 2 phases. The first phase is the smaller phase, which is 150 units between 2930 and 2030-31, but the residual 300 or so units comes in towards the end of the plan period from 2034-35 onwards. So the largest site in the town centre is already phased across the plan period. It's not all coming forward at an early point.
Okay, that's helpful. Thank you. Mr. Koff, just final question for you, really. I mean, given that backdrop, is it likely you could provide a meaningful note that would give cut-offs, or is the picture too complex and unknown at this stage?
I think it's likely to be too complex, but again, I can take it away and discuss it with my colleagues and come back and see if there is a note we can prepare. Particularly looking at this breakdown that we've got as well with the if we can get that by year, it might assist then.
I think the key point for me is when we're discussing before lunch, it was occurring to me, is there going to be a point at which portcullis comes down and which you start saying grampian conditions are necessary to prevent occupation prior to this work being in place? The reason I wanted to think about it over the lunch period was because you'd indicated that it wasn't a one-size-fits-all approach. Some sites have complications that mean it might not just be X number of dwellings equals is the threshold or the cut-off point. Yeah. You indicated that, for example, on some sites, particularly brownfield sites, where there were existing discharges, that complicated the picture.
Yeah.
You also said before about surface water flows as well, complicating the picture. So if it's not something that can be encapsulated in a neat 1 or 2 page note, I'm a little bit nervous about asking for it because A, gets too complicated, and B, might not tell me anything useful anyway. That's why I've been asking the questions.
Yeah. Okay. I mean, from that point of view, I think it's unlikely it would be that useful, and I'm just looking broadly at the figures that have been provided by the council as well. It's notable that the majority of that is likely to be towards the middle or end of the local plan period. So again, if you look at the Camberley Sewer Street Works upgrade, if that's targeted for delivery mid-AMP9, then that's going to be sort of snap bang in the middle of the 6 to 10 year period. So the amount of growth is potentially limited before that. Obviously, a lot of the growth within the trajectory is already committed development. So again, it's additional growth on top of that. But again, we'd look to work with the EA and the council. Obviously, in terms of any grampian conditions, that is a that would be a request from us in any event. Obviously, the council are the decision maker at the end of the day, and they would be making a decision based on any comments from ourselves and the Environment Agency on any application.
Okay. Comment from the council, please.
It was just to note, we obviously will provide the yearly basis, but just for the purposes of today, if you align the delivery in the town centre with the AMP period, it would be delivering 538 by 2032-33. So approximately a third, slightly less, slightly more than a third of the overall development. But that's specifically for Camberley Town Centre. There would be small sites, so we'll provide them more detail, but it's just to give you that information.
Okay. I think because it's not going to be a straightforward, you know, X number of dwellings equals we require Grampian conditions. I don't think that note's going to help me. If it had been as straightforward as that, then a note would have been useful. But given the complications Mr. Koloff has outlined, and that a site-by-site assessment, particularly of brownfield sites where there are existing discharges and network connections, needs to be undertaken, and he's added the additional point about surface water flows as well. I'm not sure how much further a note would take me, so I think we can leave that for now. Okay, we'll return then to the agenda. We're on to the second bullet point under water quality, and that reads, are water quality considerations likely to prevent or delay the delivery of development during a plan period? Question for the Environment Agency to start with. Your position statements indicate that national policy doesn't require assessment of cumulative risks to the water environment when determining planning applications, but for non-EIA developments. So does that mean that this consideration would be unlikely to affect the determination of planning applications that are not EIA development? Is that a correct interpretation? Thank you.
Judith, do you want to go on that first? You perhaps give some of the planning policy on that if you're able to. Thank you.
Sorry, can I get your question again?
It was in relation to something you said in your position statement. So it indicates that national planning policy doesn't require an assessment of cumulative risks to the water environment when determining planning applications that are not EIA development. So does that mean that this consideration is unlikely to affect the determination of non-EIA planning applications?
Arguably so, yes. But I think just identifying or highlighting the fact that this there are issues in terms of deterioration with the water bodies or the water environment, which we've highlighted in the position statements and evidence documents. I think it's important for that to be taken in consideration as well when when commenting on planning or making decisions on planning applications. In terms of the local plan as a whole, which we have raised previously, is just taking the issue of growth generally into consideration. So that definitely has to be taken into consideration. Sorry if I've not really got the point that you're making.
I understood from what you said before about the whole plan process, and you'd made that point before that obviously this is a strategic document, a local plan that looks at a wider area. I was trying to zero in on understanding the planning application process and how the Environment Agency might comment. So you'd said in your position statement that only EIA development is required to look at cumulative impacts. And I think that point had been made before. Well, obviously, that's the planning application stage. So would that mean that for non-EIA developments, planning applications, that it's not usually a consideration that warrants, it's not usually something that would generate an objection from the Environment Agency if it didn't require an EIA?
It wouldn't generate an objection from the Environment Agency, and the reason being it's because of previous proposals we've looked at in other areas. In other areas within the Southeast, where arguing about the cumulative impact was quite tricky to do. And so because of that, we had to make a decision on the fact that because that's a lot more difficult to do, it's easier, not easier, it's required when you're looking at EIA development because you have to look at the cumulative impact. So that's the reason for making that decision, which we've captured in our evidence document. But it's not to say that we wouldn't, it's not something that should be considered with a planning application with non-EIA, which is non-EIA. It should be something that should be taken into consideration by the LPA in terms of impacts to the watercourse, which is outlined in the NPPA.
Okay, thank you. The position statements from the Environment Agency also indicate the risk from development combined with wider plan growth could be mitigated by using rampion conditions to delay occupation until works to light water or Camberley have been completed. So again, would the Environment Agency only seek those conditions for EIA development rather than non-EIA development?
For EIA developments, we would ask for these conditions where we have the assurance that where we have the assurance that there is a scheme in place to increase capacity in that in that sewage treatment works. So in this case, light water in Camberley. Usually where there isn't any, it's a little bit more tricky and difficult because then there isn't any, so it's like recommending a grampian condition without actually having any upgrade plan in place. It's difficult to see how those conditions can be discharged. So at least there should be something in place to give the LPA the assurance that when it comes to the discharge of the condition, that will be possible. Because it would just be a case of, for example, if it's a pre-occupation condition and development goes ahead, there's a risk in having empty properties because the upgrades have not been undertaken at that point. But for non-EIA development, again, there are cases where we have the discussions with the LPA if that comes through. So it would be a case where we do that with Camberley with Surrey Heath as well.
Well, are they generally sought for non-EIA development, or do you reserve them for EIA development only?
We reserve them mainly for EIA developments, but we have had developments, non-EIA developments, where we do advise the LPA to consider conditions where we are aware that there is a scheme in place to ensure capacity.
Okay, thank you. Thank you. Question for the council. Is it clear at this stage whether the large developments that are proposed in Camberley Town Centre would be EIA development? Thank you.
It's not something we have considered in detail, but we believe it's unlikely at this stage.
You've had an application, haven't you, for the station site? I understand it.
We've had pre-app, but it's confidential. So
Okay.
we've not had a
Okay.
application. What we have had is an agreement. So I was getting a bit of feedback. We've had agreement on additional parking provision in Knoll Road car park for the station, but that's the only thing that's in the public domain.
Is it clear that the necessary upgrades to the wastewater treatment works are going to be in place to allow the London Road block site and land east of Knoll Road to come forward in the timescales envisaged?
Yeah. Yeah, I can come in on that point. So, so in effect, the water cycle study is a cumulative impact study because it takes into account all of the planned growth, also all of the recent completions and all of the council's commitments. And not only that within Surrey Heath, but also in any neighbouring authorities where growth will be treated at the same treatment works. So from that aspect, the water cycle study, which we've discussed, obviously the conclusions of this morning, that our understanding is there wouldn't be a detrimental impact. That is a cumulative impact assessment.
Okay. And is this an issue the council is encountering at present for planning applications?
No, sir. And that relates to the comments we made earlier, that there has been no issues raised, including on large greenfield sites.
Thank you. Mr. Barrett.
Thanks, sir. It's just a quick point really with regard to when those sites are going to come forward. And I suppose it comes back to the MPPF in terms of what's considered deliverable. So if a site is expected to come forward within the first 5 years after adoption of the plan, there needs to be clear evidence that housing completions will begin on the site within 5 years. And I think that's the point with regard to, I suppose, all the evidence we've heard this morning is what is the degree of certainty as to those sites within the Camberley area that they're going to come forward within that first 5 years, or whether actually there is a need within the trajectory and the proposed trajectory of pushing those back outside of those 5 years, given that uncertainty. I think we've set out in, and this probably speaks to the next point, sir, in terms of the trajectories of what would happen in terms of 5-year land supply in various different scenarios, whether it's a 20% or a 5% scenario, so to help you in terms of your decision making, sir. But I think what we see is there is that lack of certainty. I think not just for with regard to these the water treatment works and the uncertainties there, sir, but also just in terms of the length of time that these sites can take to come forward. So I think there is a parlous state in terms of the 5-year land supply, that depending on whether you take a 5%, 20%, and all of the various iterations, sir. But they're before you in terms of our statement to this session. But I think you've got to take into account that definition of deliverable in terms of the consideration of these sites and whether you can be certain and whether there is clear evidence that they will come forward. So it's just that point, sir.
Thank you, Mr. Barrett. Mr. Slade.
Thank you. Could I just make one point of clarification on our position around EIAs, because objecting conditions around EIAs and non-EIA developments? Just, I think it's the reason that we might not comment, raise objections, or set comments on applications that are non-EIA is not necessarily because we don't think the problem exists. It's because of the steer that we have had on where we should not be providing our advice and how we should be providing our advice. With EIA developments where there is a need for a cumulative assessment to take place, we're still under we still have the steer that we should be providing objections where necessary or requesting conditions if we think that's appropriate. That's currently not our steer for non-EIA developments, but that doesn't mean that we wouldn't necessarily think that those aren't appropriate, which is what we're trying to encapsulate within those position statements in order to give that information to the local authority as the decision maker, so that when they are making their decisions, they're fully informed of what the risks may be and what the options are to mitigate those risks. Just wanted to get that clarify that point. Thank you.
Thank you, Mr. Slade. And when you say your steer, do you mean there's been a position taken corporately to take that line across the board, not just here but elsewhere?
My understanding is that that's a steer internally, possibly directed from central government. But please correct me, Judith, if I'm wrong on that.
Yes, that's the steer, and that's the steer internally. And we do review applications that come in on a case-by-case basis as well. But internally, that's the steer. Again, it's just to highlight the risk to the LPA for them to take that into consideration when applying their powers in terms of the planning balance.
Okay, thank you. Does the council anything that's been said?
So yes, I mean that's I suppose all that we'd say here is it's quite revealing, I think, that in the context of discussion that we've just had. I mean, you asked the question quite a few times about this cumulative point, and you know, we had sort of, yes, we really do, we only ask for it on cumulative, but we might be telling the council to consider it on other sites and so on. But when it comes down to it, there appears to be a steer from central government not to be going asking for such things in relation to non-EIA development. And I think there's you know, that's quite important, because it shows that this isn't really something that should be considered to be an impediment to the delivery of housing when you take a proportionate approach and when you look at the evidence as well. And what the government's really saying is that you know, you need to look at this in a sort of a sensible way. With EIA development, there are cumulative impacts that are taken into account. But I don't think you're really getting an answer from the EA that's saying, yes, you must consider Grampian conditions on non-EIA development. And there's a reason for that. And not least because central government's saying that as well. That's consistent with our position.
Okay, thank you. I mean, one thing the Environment Agency's position statements do say is that for EIA development, the cumulative impact is likely to present an unacceptable risk of water pollution. So that would be the Environment Agency's position were any of these schemes to be EIA development. What's the council's response to that, please? Thank you.
Well, first of all, I mean, I don't think we're in a position to say that any of this development is EIA development. Just looking at it from the context of Schedule 2 of the EIA regs, doesn't look like it is, but obviously one can't say it definitely wouldn't be, because there'll have to be a screening and a scoping and so on. But just on the face of it, it doesn't look like, when you're looking at the schemes that are set out there, that they would be. But cumulative is cumulative with other EIA developments, so there'd have to be quite a few of them together. It's not just any development. So, and I think so you've got our overall point. Based on our evidence, there isn't going to be any issue in the first place. And that's what Mr. Eccleston, I think that it has to be the starting point. We don't consider that there is, I mean, you've heard all of that, and you've heard why. So taking that into account, and then you've heard from Mr. Eccleston, I think that there has been a cumulative assessment in any case. So I mean, I can understand the reason that the question is being asked, but and you're obviously working through the EA's statement, but I think our position is quite structured. First of all, you've got the evidence on a more granular, nuanced level, dealing specifically with the impact. We don't think there's deterioration. In any case, our assessment looks at cumulative impact. And then thirdly, it's very unlikely these are EIA developments. Even if they are, the cumulative impact has been taken into account.
Thank you. And what about Mr. Berrent's point that this consideration adds further uncertainty about the ability of some of the larger Camberley Town Centre sites to contribute to the 5-year supply?
Yes, thank you, sir. Thank you for coming back on that. I mean, I think again, you know, one has to stand back and look at this in a straightforward manner. I mean, if our position is that there isn't that uncertainty for the reasons that we've already rehearsed with you. So just the mere fact that there is an argument or discussion going on about water quality doesn't just per se give rise to uncertainty. We're quite confident that there isn't uncertainty in that respect for the reasons we've already given. And it certainly doesn't undermine the trajectory or the delivery. I mean, for that matter, so one could say, if one was going to look into hypotheticals, one could say, well, the government currently is supporting station car park development. So we could say, well, that's adding great certainty then to delivery. So one has to look at it from an evidential basis and not just, I suppose, raise what ifs. From our perspective, evidence-based, reasoned, with expert input from JBA, which are a very respected consultancy, and I think advise the EA themselves. In that respect, we don't think any of this adds any uncertainty. We think that on an evidential basis, applying the correct principles, you need not be concerned about any further uncertainty.
Thank you. Mr. Collins. Sorry, Mr. Collins, you're on mute still.
Oh, sorry, my fault. First mute thing of the day, so there we are. Look, professionals do disagree, so that's fine. That's why we're here debating it. My opinion is that at the very least, the larger one of the town centre sites, which is London Road Block, would be EIA development. Looking at Schedule 2, it's over a hectare. I think it's about 1.8 hectares in size, certainly over 150 units, and we'll have a larger floor space. Now, except that doesn't mean automatically EIA is required. You go through the screening process, but you look at significant environmental effects or likely environmental effects. One of the things that a decision maker is going to look at is the very water quality debate that occurred at the local plan examination, which is happening today. So that is just my opinion. Take it on face value. I would say Knoll Road's probably borderline, and I would say Camberley Station isn't EIA development, but that's just my opinion. But you need to remember that all of these would involve demolition, and that in itself could trigger EIA, as we know from case studies. I mean, it's just some concluding points just for me on this aspect of the question. I think what it's important for us to stress from a history perspective is that we're not objecting to the principle of these developments occurring. We've been consistent on that point throughout. What we are simply pointing out is that you've heard nothing today from either the Environment Agency or Thames Water to say that they're not going to object to these proposals. In fact, both parties have made it abundantly clear they're considering Grampian conditions, which doesn't fill me with a great amount of certainty or surety that these sites would deliver as quickly as the council are saying. We know Thames Water have in their pipeline AMP9, I think it is, and Mr. Bennett will start whacking me under the virtual table if I'm getting these things wrong, but they're saying the upgrade should trigger by 2022-23. It's a 32-33, which is fine. If that happens, great, good for everybody. In reality, that means that the planning applications that go in, say 2030 to 2031 for these three sites, they'd have to be timed around then from an investment viability perspective, because you'd imagine you'd have to wait until that point to have the certainty, the final certainty that Thames Water are undertaking those works and it is happening. Because until there's that certainty that those works are happening, definitely they're underway, they've got all the necessary permits, consents, etc., you wouldn't speculate or risk the funding to progress the planning to then deliver a housing unit for occupation from 2033. You just wouldn't do it because of the risks involved. So in summary, we're not saying these things won't happen. Indeed, it's great that everyone's debated this today to make sure that they do eventually occur, but it doesn't seem credible to imagine that over half of the housing that was included in the helpful table from the council, which the council shared earlier, would come forward before 2033. There's a blocker, which is an absence of wastewater treatment capacity. Sorry, thank you. That's my point. Mr. Bennett, is there anything I missed there?
No, I think that's fine.
That's 3 times in a row. There we are. Well done.
Thank you, Mr. Collins. The council wish to come back.
I was just going to reiterate that London Road Block is split over 2 phasing periods. The first phase is for only 150 units, and the second phase, which is for the majority of the development, is phased from 2034-35. That's the single largest site. The other numbers we're speaking about aren't too dissimilar to sites that have already been coming forward in the wider Western urban area, and again had no objections from the Environment Agency. Land West Sturt Road was around 180 units and is in our 5-year supply. The site at Williamson Square, 170 units. They've not been EIA development, and they've not had these implications. There's no evidence from us other than speculation as to why there'll be a Grampian condition put forward, especially when our evidence is quite clear that the planned growth for the local plan is not seen to have an impact in that way. And I'll just pass my comments.
Yeah, just picking up, I think that point. I think again, I think it's important not to have too much loose language, because I think that Mr. Colliff for Thames Water has certainly not said that he's going to be advising every development to have a Grampian condition. He's just mentioned it as a potential tool if there is an issue, but he hasn't said anything about, oh yes, we're going to be objecting from now onwards and asking for a Grampian. And frankly, neither has the EA. They've just said in some EIA situations, they might need to consider that. But the important point here is that, again, you've heard evidence about the location of these sites, the fact that they already have connections. Mr. Colliff has made it very clear that there'd have to be some sort of a detailed consideration before being concerned about these matters. So again, I don't really think that the fact that Grampians have been discussed today has any great moment. Nobody's been saying that, yes, from now onwards, every single scheme coming forward needs a Grampian. And as Mr. Bartlett has just said, that the council, the EA has never asked for that, have they, so far? And neither has Thames Water.
Thank you. Mr. Colliff, do you wish to respond to anything that's been said, either by the council or Mr. Collins or others?
No, I agree. Obviously, in terms of Grampian conditions, like they say, that's a tool that we have to request if needed. In our view, obviously, the council are then the decision maker, so that they'll be looking at our views, but the views of others as well. In terms of the timescales for delivery, again, if you're looking at upgrades and certainty of delivery of upgrades, obviously these things do take time to build. An example, the storm upgrade, which is currently proposed to be delivered in 2028, is going to take around 18 months to complete at Camberley sewage treatment works. So again, on that basis, obviously we should be fairly well advanced with the progress on those upgrades by early AMP9, going through any consent process EIA screening with a good indication of the time frame for delivery. So that again may provide more certainty for developers if there are concerns. Assisting with investment, if you know the works are on the site and it's a 2-year program to complete, for example, it gives that better certainty than we're at this point in time, where obviously we have schemes that are proposed, but the detailed design needs to progress and obviously take account of all of these developments in the local plan.
Thank you, Mr. Colliff. Did the Environment Agency wish to come back on anything that's been said? I noticed that Ms. Montfort had a hand raised before.
And I think one thing that I also wanted to add is having some of these internal discussions about looking at the strategic direction and also solution, then negates the need for having to discuss Grampian conditions at that stage when it comes to it, as looking at planning applications, because it would have dealt with at the strategic stage in terms of having a clear timeline of upgrades which would accommodate growth. So it's just important for these for this to be looked at. That's the reason why we are highlighting these. Yeah.
Okay, thank you. Any final comments under this point before we move on? Okay.
Sorry,
thank you.
So just one point. I think that on behalf of the council, take all these points on board, but I think what we consider that our evidence shows you that what is before you and the expertise that we've put forward demonstrates that these matters have been considered. They have been carefully taken into account throughout the process, and we have reacted when asked to do so by the EA or any other party that has points to make. We've responded, and as a consequence, we're confident that these matters are adequately addressed in the way that we've sought to say to you today.
Thank you. Okay, then we'll move on then to the third question, which is the housing land supply scenarios. I think it's pretty worth saying at the outset that the purpose of this part of discussion, from my perspective, is simply to discuss the two tables that were produced by the council during the hearing sessions. It was documents SHBC20 and SHBC27. In that regard, I don't intend to revisit the discussion we've already had, but I do want to ensure that those two tables present accurate figures so that I can understand the implications of them. Question for the HBF to start with, Mr. Barron. You produced a table in your hearing statement on page 3 of your rep that presents adjusted figures for the table the council produced in its SHBC27 document. I think to start with, it'd be helpful for me if you could just walk me through how you've reached those figures and the alternative assumptions that you've applied. Thank you.
So yes, in terms of the table 2 in our statement, I believe that's the one you're referring to in terms of the 5%, 20% buffer. Basically, what we've done with this is, as per our comments with regard to the hearings, with regard to sites HA2, HA3, HA/03, we've moved those sites back outside of the 5-year housing land supply. So effectively saying that there isn't sufficient evidence on our considerations to include those within the 5-year land supply. So just push those back in terms of the trajectory, and therefore undertaking the 5-year housing land supply on the basis of those sites being pushed outside. And I think that was really, sir, to give you an understanding of our position, sir, from the hearings in relation to the tables that have been produced by the council in terms of SHBC27. So that gives you an understanding as to what we've just discussed there. So in terms of the whether some of those sites within the Camberley town centre will come forward, and that what that shows, sir, is that actually on a 5% buffer, yes, the council will be able to show a 5-year land supply on adoption, but actually if there's a 20% buffer applied, then there is a risk that the council will not have a 5-year land supply adoption, will have a 4.53 year. So really, it's just about ensuring that you, sir, had the evidence to hand on the basis of what the council has submitted in SHBC27 in terms of our representation, sir, at the hearings and considerations of the hearings with regard to those sites and the deliverability of those sites, sir.
Thank you, Mr. Barron. I'd appreciated that about table 2, which is on page 4 of your representation. Table 1 was the one that, and I understood that table 2 had sought to remove those larger sites from the 5-year period. Table 1 appeared to me, at least, to be in effect a corrected version of the table the council had produced in their SHBC27 document, but retaining those sites in the 5-year supply. It was just to understand exactly what assumptions had been altered to reach the different figures. So, for example, if I look at your table 1 on the one hand, and I look at the council's SHBC27 table on the other, it's understanding what adjustments you've made to reach the figures you've reached, Mr. Barron. Thank you.
In terms of adjustments, I think it might be the approach that I've taken in terms of or what I consider to be the correct approach to considering 5-year housing land supply. And I think it's with regard to the shortfall that exists and how that's applied. In terms of the shortfall I take, it's the shortfall from the year prior to the 5-year housing land supply being undertaken. So with regard to So say is that there would be a minus 81 applied to 26-27 in terms of the 5-year housing land supply. With regard to that table 1, I don't think the council have undertaken that, or they've used a different figure. So it's really just setting out how I believe it's all set out in terms of the rolling trajectory, sir, that I've set out in Appendix A, and Appendix B sets out the figures that I've taken in terms of those. And it's just, I had a different outcome in terms of my calculations, not significantly different to the council, but just wanting to present those in terms of actually the approach that I've taken. And I think that is the difference that I've arrived at, but I don't have those exact figures for the council. I couldn't replicate the council's figures in terms of that, and that's the position I've taken, sir. In terms of the approach, in terms of our Appendix A, sets out actually how we've done that, and also then in terms of, it might also be where it's sometimes seen that councils add the deficit there's any within a housing supply. They then don't apply the buffer to that deficit. The deficit is applied after, and that may well also be a differential with the figures between my figures and the council's. I would suggest that in terms of PPG, it's clear that the deficit is applied to the before you then apply the buffer. So the buffer applies to both the deficit and the requirement itself. Thank you, sir.
Thank you. I mean, I do enjoy a good discussion going into the nuts and bolts of housing land supply calculations. But just so I've understood you correctly, Mr. Barron, the first point you made, is that the old Liverpool versus Sedgefield approach about any shortfall accrued from the base date of the plan to the start of the 5-year supply calculation, whether that's entirely within the 5-year period or whether it's spread out over the plan period? Was that the first point, just so I'm clear?
It's not. It wasn't the first one. I have used the Sedgefield method because that's what PPG suggests that should be used in terms of applying any shortfall is delivered within the first 5 years of the plan. So yes, I have used the Sedgefield point.
And but that wasn't the first point of difference. You were making a different point from that.
Yes, sir. It's in terms of this is where I'm not sure where the council have terms of the figures, in terms of where what deficit they've used in terms of and where they've taken the deficit from. I do know some local authorities use a deficit from the year in which you're taking undertaking the 5-year land supply, whereas you take the deficit from the year before, in terms of from the period before, and apply that into the 5-year land supply. So, as I said, sir, our Appendix A sets out how we've arrived at those figures. It's sort of clarity in terms of that. But it is different to the council's approach. But how the council is, I've looked at it and I couldn't work out where their deficit figure came from with regard to their consideration. So it was just wanting to set out our position based on what PPG says in terms of assessing 5-year housing land supply, and setting those out in detail for you, sir, in terms of our appendices, and then applying the other elements to it, so you have a clear picture of our position with regard to the 5-year land supply across the plan period.
Okay, thank you, Mr. Barron. That's helpful clarification. Council team's hands raised. Do you wish to come in? Thank you.
Yes, so it's just to hopefully provide some clarification. In our note, we do provide 4 bullet points, which include what our assumptions are based on, and that's how we've arrived at the figures we have. I believe it's how the backlog is being dealt with, where that assumption differs. But we feel we've been quite clear on what our assumptions are based on. And if you apply different assumptions, you will arrive at a different figure.
Have you been able to identify the differences between, I mean, Mr. Barron has said that he's unable to arrive at the figures that you've arrived at, Mr. Bartlett. Have you had a look at Mr. Barron's figures and found where the differences arise?
I think the main one is likely in how the backlog's being treated. So at bullet point 2 of our statement, it says for scenarios with a 2023 plan base date, undelivery is based on confirmed completions. we're currently in the completion year, and I believe that one of the completion years that there's been a backlog deducted from HBF is for that year we're currently in. This was the approach we've taken, but that would lead to a slightly different output nearing the region of what's here. And I'm also not sure on how Hart's being taken into account in the calculations, but we've been clear that we've included Hart contributions up to April 2025 in scenarios, because that is when their plan gets to the post-adoption stage, which was discussion we had in the previous hearings. And when we do undertake the housing delivery test at the moment, there is a deduction made for Hart unmet need in that assessment. But that, again, it comes down to that's just the assumptions we've applied, and we feel they're fair assumptions, but others may come to a different view.
What about Mr. Barron's point about the buffer being applied to the accrued backlog? Is that the approach that's been taken in Surrey, Heath?
I believe so. I'd need to double check the figures, but in any event, it would have a marginal impact, because it's really how much the backlog is in the first place as to how much that deducts from 5-year housing land supply. The buffer itself, especially around the 5%, would not be significant on that backlog point.
Mr. Barron, do you wish to come back on anything that's been said?
I agree that there'd be small differences, and I think that's the. I would agree with the council in terms of that. In terms of we've applied different scenarios in terms of that backlog. I would say that our position is correct. I think it's then one set out within the rest of the our response to that is really providing with a clearer idea of what the impact is in terms of the different assumptions that we discussed at the hearings. I think following on from those discussions and the note that's been provided by the council in terms of what is the long-term outcome of that, both in terms of shifting the plan period forward, but then also extending it, and the shortfalls that are there that then occur in terms of over the whole plan period. Obviously, that's for you to take in terms of those considerations moving forward. But what we wanted to provide you, HBF and colleagues around the table, is a clear picture of what those impacts are on the basis of the latest supply figures that are being produced by the council. And I think it's recognising that the 5-year land supply, in terms of some of those small changes, are small, but actually when you look at over the long period, there is significant shortfalls in terms of housing land supply over a policy compliant plan period, and also real problems in terms of the 5-year land supply moving forward across the plan period. I think those are the difficulties we see with this plan, sir, is that if those 3 sites that we say are not deliverable, don't come forward, on the 20% buffer that would be required from July 2026 next year, the council won't have a 5-year housing land supply. The plan will be effectively out of date. I think in terms of that, if it's a 5% would only apply from pre-July, yes, they do have a 5-year land supply, even if those sites don't come forward within that. But it's just really wanting to set out for you, so the clarity as to what our point was in relation to the discussions and conversations we had at the hearings a few months ago, sir. Thank you.
Thank you, Mr. Barron. I'll take a final comment from the council. I think we'll move on. Does the council wish to come back? Thank you.
Thank you, sir. Yeah, it's just to note that when we produced the note, we were asked not to include the impact to town centre sites, so that isn't included in our assumptions. But in any event, even in the HBF's assessment, if you apply a 5% buffer in any scenario, you still arrive at 5-year housing land supply. And in any event, we're required to look at from adoption. We wouldn't, in the note, we've not included the rolling 5-year housing land supply. We've already made our point on the 20% buffer in decision-making purposes, not in plan-making purposes, so I won't go over that. But it's just to really say that with a 5% buffer, even if you take the most conservative assessment here, you still arrive at a 5-year housing land supply. And that's notwithstanding any changes we would have seen Since this assessment was undertaken, there was a grey belt site approved for 30 units in Chobham very recently, and as I mentioned earlier, the Snows Ride site is now at appeal, which was overturned after recommendation to approve.
Okay. Thank you, Mr. Bartlett. Okay, we'll move on then to point 4, which is the final point on the hearing agenda, which are the proposed modifications to policy DH8. We'll just call those up quickly.
Just to note, we're having a slight move around in the room, so there may be a 1 minute delay from our part.
That's fine. I'll give you a minute or two to arrange the rolling substitutes bench.
Thank you.
Sorry, sir. May I excuse myself also, because I'm not required of this last matter. I was going to say goodbye. Thank you, sir.
But by all means, Mr. Collins, and same with anyone else who doesn't have an interest in this final point. I'm happy for you to leave if you wish. You don't need to stay. It won't be I won't take it as a slight anyway if people wish to leave the final session.
Thank you very much, sir. Goodbye.
Yeah. Thank you, Mr. Collins.
Does this relate to the net zero policy?
It does. So the council, during the hearing sessions that we had in September, the council, well, I'll perhaps say this by way of context, Mr. Slade. So the background to this modification, which the council has proposed to policy DH8, which relates to zero carbon buildings. Originally, the planners submitted had a policy that required major applications to deliver net zero carbon development. However, the original policy didn't define what it meant by net zero carbon, and I had a number of questions I asked of the council about it in September. And I also asked it in relation to viability during the viability discussion. So the council then took those comments away and produced this note in response. And I felt it raised substantive enough points that I wanted to reopen it for comments as a modification document. So it does relate to the net zero policies, yes. Happy for you to stay, but if you feel that it's outside of your area of interest or remit, I'm also happy for you to leave.
Apologies about the cat. I think it's probably maybe. It's interesting as it does sound. I don't think there's anything I can contribute to. So if it's okay with you, so I might nip off as well. But thank you very much for having the discreet hearing and taking our comments on board. Is much appreciated.
That's fine. Ms. Montford, did you wish to say something as well?
Yeah, just similar. If it's okay, I'd like to duck out as well. And just wanted to say a very big thank you to you and also to the LPA for arranging the discrete session to hear us out in terms of water quality matters.
Thank you, and thank you to Ms. Montford and you, Mr. Slade, for appearing today. Your contributions have been much appreciated. So thank you for that.
Yeah, good luck with the rest of it. Thank you.
Okay, thank you.
Good afternoon. Cheers. Bye.
Okay, as I said, we had lengthy discussions about this policy back in September, and I asked an awful lot of questions on viability, and I think those questions, and on principle as well, and that's what's led to this proposed modification, which we're here to discuss now. Question for the council to start. The 2023 written ministerial statement on energy efficiency sets a fairly high bar for local policies that propose local energy efficiency standards, for buildings that go beyond current or planned building regulations. And in particular, it states that any additional requirement should be expressed as a percentage uplift of a dwelling's target emission rate. So what's the basis for departing from that approach here? Thank you.
Thank you, Inspector. Bronwyn Chinian for the council. So yes, the basis for departing from that is that the 2023 written ministerial statement doesn't change the legislative powers available to local planning authorities to bring forward policies that go beyond building regulations, nor does it prevent such policies from being justified. And so the legislative powers that we're referring to are the Planning and Energy Act 2008 and also Section 19(1)(a) of the Planning and Compulsory Purchase Act 2004, being the legislative powers available to us to set higher than national and building regs targets for mitigating climate change. It's necessary to set these targets, which go beyond just the regulated emissions and cover also non-regulated energy emissions, because these non-regulated energy emissions contribute a significant proportion to the overall operational emissions from a dwelling. And so SAP targets, which only consider regulated emissions, are insufficient. So the proposed absolute and whole house energy intensity targets and other associated targets that we're proposing in the modification to DH8 to define net zero are based on a very thorough, robust evidence base conducted by the County Council on behalf of boroughs and districts, which is set out, and we've already discussed it. So we have drawn the targets that we're setting from that evidence base, and also we have demonstrated that the targets that we're setting are not going to be detrimental to viability of development for the major housing development, because we tested the future homes standard in our viability testing for local plan, and we demonstrated that the scenario 4 targets that we're proposing for the levels of space heating demand and overall energy intensity can be delivered at not particularly different costs to the costs of future home standard. So therefore, which is not detrimental to viability. So therefore, our proposal is sound in that regard. Also, I would say in terms of being effective, then the proposals are made also in line with many other local planning authorities around the country who are taking a similar approach beyond Surrey, and also within Surrey there's Epsom and Ewell who are currently in examination as well, who have taken a very similar approach to our proposal. Some of the examples of the other councils are given in our evidence base, but just to name a few, Cornwall, Bath and North East Somerset and Central Lincolnshire, and also Uttlesford in Essex is currently going through hearings this summer, and they have had no modifications requested to their proposed energy intensity targets, and in fact their targets are actually more strenuous than our proposed targets. So those other three, for example, the Bath and North East Somerset and Cornwall, propose very similar targets to us, and they certainly do include the non-regulated energy sources of emissions, which are beyond just the regulated ones covered by SAP. So that's our position, really.
Okay, thank you. I mean, I think there's two points I was trying to explore here. Firstly, there's the justification for going beyond the future home standard or the building regs. And then secondly, if going beyond, I think the question was particularly focused on this, if going beyond the building regs, then doesn't the written ministerial statement say that the approach to be used should be to adopt a percentage uplift to the dwelling's target emission rate? So given that you've decided to go beyond the building regs and you feel there's a case for doing so, why have you gone for a standard that is not that specified in the written ministerial statement? Thank you.
So the written ministerial statement is a material consideration, but it is the weight which needs to be given to it, we would suggest, is not, not to the level that it should overall supersede the underlying legislative powers that we have available to us. And those powers require us to make sure that development in our area is sufficiently mitigating carbon emissions towards the impacts of climate change. And so in order for that to be sound, we do need to consider the non-regulated energy emissions, which are considered, sort of outside of the SAP methodology. So that's the justification. And also in terms of the costs, if you compare in our note, in SHBC24 on page 2, we show an extract, table 3.1. It's called Additional Cost for Residential and Net Zero Carbon Scenarios. And in that, I've highlighted in the dark green outline section that the scenario 3, which is the improvement using the SAP methodology, as suggested we should by the written ministerial statement, is in the case of, for example, the house and the flat scenarios is actually, the house scenario is actually more expensive to achieve than the version we're proposing, which is scenario 4 using the space heating target of 30 and the overall energy intensity target of 40. And the house and the flats costs are not too dissimilar, only a few pounds between them per unit. So overall, there isn't an additional cost to development to developers for going for the more holistic approach that takes into account the non-regulated types of emissions and also takes into account the built form of the development, which is increasingly important when we think of adaptation to climate change and overheating. It's really important that we consider these things in the round. So so that would be many of the reasons why we would take this approach. And it's based on the best practice as set out in the Surrey County Council Viability Toolkit, which is based on a thorough energy modelling across a number of different types of units.
You say there's no additional cost. I appreciate that's taken from the findings of the viability study. But is there not a danger that if each authority takes its own approach and some adopt the written ministerial statement, some go with the building regs, some take a different route, that it ends up with a kind of confusing patchwork across the country, such that it's having to, rather than a standard approach being taken or one of two approaches being taken, you have what developers are faced with is a kind of multiplicity of approaches. And in that regard, I know that the written ministerial statement says that proliferation of multiple local standards by local authority area can add further costs to building new homes by adding complexity and undermining economies of scale. So what's your response to that point, please? Thank you.
So our approach is based on very sound evidence. It's part of an emerging body of LPAs across the country who are have had plans found sound that include these exact targets. So I think that it's not necessarily developing a multiplicity of different approaches. It's starting a trend of a new direction, which is based on much more on the sound and energy modelling, which is set out in the evidence base that we have used to support our policy. So it's soundly based. Mr. Bartlett has something else to add as well.
I think it's also important to note that this is a Surrey-wide approach and it is evidence-based Surrey-wide. That's at a population of about 1.1 million people. So it isn't just Surrey Heath. We are looking at a broader evidence base for Surrey, which will likely feed into the unitaries that have recently been announced.
Okay, and a number of examples have been highlighted of where a similar approach has been found sound. Just for my note, could you just repeat those for me so I've got those down, please? A number of examples were given, but my pen can only move so fast across the page, unfortunately. So it would assist me if you could just repeat those examples of where a comparable or a similar or the same approach that's being proposed here has been found sound recently elsewhere. Thank you.
So those authorities are Cornwall, Baines, which is North Bath and North East Somerset, and also the 3 LPAs which comprise the Central Lincolnshire combined local plan are named in particular, and most recently as well, Uttlesford in Essex has proposed targets that are using the absolute energy type of targets, and those are very interesting as well because although not fully concluded yet, they are actually more demanding and the planning inspector has not requested any modification to the that level of target. But yeah,
Okay.
Cornwall, Baines and Central Lincolnshire most specifically direct you to.
And final question before I let Mr. Barrett come in, because he's had his hand raised patiently for a while now. You mentioned the Surrey-wide approach is being taken. So is this approach that's being proposed here being taken in neighbouring districts through their local plan preparation as well? And if so, could you give me the names of those districts? Thank you.
Yes, in Epsom and Ewell, they have taken the same approach using the same evidence base. So we are consistent with others bringing forward plans at this same time.
And just to add to that, sir, a number of the plans in Surrey are at an earlier stage of the plan making process. Epsom and Ewell is one of the ones that is at a similar stage to us. I believe Spelthorne are, but they did start earlier in the sense of the Reg 19. But it's worth noting that this evidence base is supported by all districts and boroughs in Surrey. They all had input into it. So it is very much a joint approach looking to find a holistic way of dealing with this type of issue in Surrey.
Okay, thank you. Mr. Barrett, do you wish to come in?
Yes, sir. I think the first point in terms of Cornwall, Baines and Central Lincolnshire, I think those were all prior to the written ministerial statement being produced. So I think there was a lag between some of these policies coming forward and the written ministerial statement. I think with regard to the multiplicity of standards, I think we've got the building regs, but we've also got the future home standard coming in. We've also got the potential for the home energy model, which is the replacement for SAP coming in, which will replace that and address some of the issues around the performance gap, I think, which is the case of why local authorities are saying, actually, we don't want to use SAP, we want to use Passive House Performance Package or SHBC 54. So there's all these different elements to it that the council are introducing whole new approaches to assessment in terms of the building standards. And I think this is the point that the written ministerial statement points to, is that a multiplicity is more than one. So if we've got different standards in different areas, and the council have already pointed to Uttlesford being slightly different to Surrey, and then we'll have areas that will have say in London, you have an 100% improvement on the 2013 building regulations, but then we'll also have the future home standard coming in. And this is the difficulty the development industry has, is that it's trying to ramp up delivery and increase delivery and support delivery whilst trying to understand the various different standards that are being put, and not just different standards in terms of, say, energy use, which is part of that, but also different methodologies for assessing that and assessing the performance of those homes. And this is the evidence that I don't see produced by the council, sir, is not just in terms of viability, and I think the written ministerial statement does talk about this in terms of delivery. Can the sites and the sites that are being proposed in will there be any delay to the delivery of these sites? Will there be a delay to the delivery of homes? And it's that consideration. Viability is one of those. What we haven't seen is, with these types of standard, is significant large-scale development and how these types of standards have an impact in terms of delivery, because we just haven't got there with that yet, sir. So there is still uncertainty as to how these are going to be delivered, because they require significantly higher air tightness standards than we currently build to. So that's a new set of skills. There's a new set of trades that need to come in to deliver that, and those are the elements that haven't been considered by the council with regards to this, because they've adopted a standard here that's host the submission. So what you're being asked to, sir, is to include within policy a standard that doesn't meet the national policy set out in the written ministerial statement in terms of that. The improvement is meant to be around improvements over and above the building regulations based on SAP. SAP is based on regulated energy. Regulated energy is something that that we as an industry have some control over. Unregulated, we don't have. That is how a home is used. So even if the council were to say, okay, we'll have this energy use and then we'll monitor that energy use, we as a developer can't control then how that homeowner it uses that heat, what energy use they have. And I think these are all the difficulties that that aren't necessarily being considered by the council in terms of implementing this. It's just ramping up in terms of another standard that will inevitably slow down delivery. As developers go, well, actually, how am I going to meet this? It might be viable, but do I have the skills? Do I need new skills to bring into this? What cost will that impact in terms of the delivery? So there's significant uncertainties over what the council's proposing. Fully recognise that there is a need, that there is the legal that legally they can do this. The Planning and Energy Act sets that out, but the Energy Act does say that it should be within the framework of the policy set out, or the legal framework set out by the government in terms of regulation. So it does set out that the Secretary of State can say it is within these parameters, and that the council can't just then say ignore those parameters and say, oh, we think we've got a better approach to it. And I think that's our concern, sir. We would say that actually the Future Home Standard, as and when it comes in, will deliver the significant improvements, will deliver that net zero target by 2050. And I think, and it will also deliver the consistency in terms of building regulations. And essentially, I don't think planning is the place that this should be done. And I think our HBS position is that actually, if you want consistency, if you want to boost supply, you need to have a consistent national approach that we're all working towards. And actually, there's a lot of difficulty in terms of actually how it's assessed, who then undertakes the assessment, the type of assessment framework you use, what the council then understanding of that assessment framework, do they have the skills in-house to understand that in terms of the decision-making process. So there's a whole range of difficulties in there that aren't really necessarily explored within the council's evidence. And I think that's my difficulty with the council's evidence, is that it's broad. In terms of the costings, I don't have sort of any particular concerns in terms of some of the costings. It could be higher. To be honest, we just don't know until they've been implemented, until we've started to deliver these sort of standards on the ground. So that's our concern, sir. But recognise that legally the council can go beyond, but it is clearly within a very specific framework set out within the WMS. Thank you.
Thank you, Mr. Barron. And just so I understand your point about delivery fully, is that a point? Is the delivery point you're making, is it because it's a different standard here than would apply to most of the country, that developers then have to spend more time calibrating their designers to meet that, and that there could be an issue with the availability of professionals over that? Are those the two kind of points that you're buttressing that argument with?
Yes, sir. It isn't necessarily all just about the basic. What's the increase in the capital cost of delivering that unit? In terms of, it is actually, I've got a standard housing type. I've then got to figure out how to amend that housing type to meet a higher requirement. What changes in terms of installation, what changes in terms of windows, what changes in terms of the design of that house in order to deliver that. So there's a whole range of aspects that you have to think about before you get to the stage of actually going, well, actually, can we deliver this? Can we meet that standard within all the other parameters that are set out within the local plan in terms of design and the rest of it? So it just creates an additional amount of work. And then you obviously got the professional skills, but there is the skills in terms of the construction industry, in terms of ensuring, and I think this is especially around when you're using energy use intensity targets and space heating standards, is the level of air tightness that a building must achieve. And I think this then relates back to things like the use of the Passive House Performance Package, which is often a performance method assessment tool that is required by local authorities around this, and is what's promoted by LETI, which is the organisation that has been promoting these standards. So there's all these difficulties and differences in terms of assessment processes, the skills needed to actually achieve that, but the skills needed in terms of reconfiguring housing types to meet that, but also then the skills in terms of the assessment of performance of each unit within that development to achieve that standard. So there's all these difficulties that aren't necessarily explored within the council's evidence, which I suggest should have been, and why I would say that at the moment it's not justified. And actually, the most effective method would be to rely on the building regulations and the introduction of the future home standard, sir.
Is it your experience, Mr. Barrett, that there is a gap in the number of professionals required to undertake these assessments as to whether these standards are met?
So we don't know, because we've only recently had these standards come in terms of somewhere like Cornwall and Bath and North East Somerset. I think there is a lot of work still going on in terms of the Future Homes Hub, who are working with government to understand what the impact of the Future Home Standard is going to be, let alone what the impact of these types of standards coming forward. We're working with our members to try and understand that and understand what those costs were, but it takes time for us to understand that. And granted that outside of areas such as Surrey, Heath or Cornwall, our members are focused on actually how do we get to deliver the Future Home Standard. That's the priority in terms of delivery and improvement, because that is the standard that will be applied across the country. So then having to figure out how we're going to meet an additional standard in addition to the Future Homes, a new standard coming across in building regulations, is difficult and is going to be challenging. And I think those are the aspects that it's very difficult to get across. Is we want to see improvements, but we want to see those consistent improvements across the country so we can most effectively deliver new homes, as well as deliver those improvements in terms of working towards lower energy homes and reduce carbon in terms of the energy that's emitted from those homes. So I think that's our key concern, sir.
Okay, thank you, Mr. Barrett. The council wish to come back on any of those points? Thank you. We lost the council. It's very easily done if you just press the wrong button on Microsoft Teams.
Yeah, I'll see if I can get them back.
Apologies, everybody. We're just going to get back onto our screen. We accidentally ended our meeting, but we'll be in just 1 second. Please bear with us.
No worries. Thank you.
That's in. Sorry, sir. My sincere apologies. The mute button is directly next to the leave button, and I clicked it by accident. So my apologies. My colleague Bronwyn will come in now.
It's easily done. Not to worry.
Yes, I mean, I was just going to respond in relation to a couple of points. In terms of the Future Home Standard, we set out, or we refer to the evidence set out by the Surrey viability study that explains why local authorities should not rely on the Future Homes Standard to deliver the required climate change targets and contribution to mitigating climate change, because the standard is currently uncertain. So the government is still consulting on it, and it's possible that it could result, one of the two options tested in the government consultation didn't have any on-site sort of PV, and the costs of running those homes would be a lot more expensive, and would be the costs to the developers are then also set out in our table, which is explained where it says option 2 is a sort of saving on the building regulations, ironically, whereas obviously option 1, which includes the air source heat pump scenario plus solar PV, is estimated at sort of 5,600. So we don't know what Future Home Standard will look like yet, but notwithstanding that, it does seem that it doesn't give very much sort of weight to improving overall sort of energy efficiency. So we are concerned that it doesn't go far enough, and that is set out on page 44 of the Surrey Net Zero Toolkit. I think it's the SHBC20 on page 44, the last page of that document. Furthermore, I would also refer you to the Essex open legal advice, which sets out in very clear and very extensive terms how local authorities have the powers and should strive to go beyond the targets of the of SAP and the building regs, and to, in the context of the written ministerial statement, with many case studies and points of case law set out. So there is a link to that, but I can sort of reiterate that that's on the Essex open legal advice for net zero, and there's a 50-page link which we have sort of referenced already through our reference to the Surrey Net Zero Toolkit, but it is a very thorough piece of evidence. And in relation to the skills, then yes, increasing numbers of developers are recognising that they need to go further in terms of airtightness, and that there are developers developing these newer standards. So and some of those are set out by in the evidence base. So we do think that it is deliverable and the right target to be requiring for major development.
One point you made before Mr. Berrant spoke was that there'd been a number of plans found sound with similar targets included within them. Cornwall was mentioned, Bath and North East Somerset was mentioned, Central Links. Have any local plans been found sound with those standards after the written ministerial statement was published in 2023? Because that was Mr. Berrant's contention, was that all the examples that were cited predated the written ministerial statement. Thank you.
Off the top of my head, I would only refer to the Uttlesford one in Essex, which is currently sort of going through examination. But if you would have time in your sort of deliberations afterwards to consider the Essex Open Legal Advice, it does set out all of the details around the timing. So the answer could well be in there, but apologies, off the top of my head, I'm not quite sure in relation to that point. But yes.
Another follow-up question I had was in relation to, and obviously the council has criticisms of the SAP approach, standard assessment procedure, but presumably the government would have been aware of those perceived shortcomings in deciding to refer to it in the written ministerial statement. So I appreciate that the council has concerns about what it perceives to be gaps in that assessment process. But presumably those gaps were known prior to the government encapsulating them in its own national guidance. So if that's the case, then what would be the basis from departing for it on that justification alone?
Well, the energy modelling set out in the Surrey Net Zero report sets out, you know, the full case to explain why it is more a holistic approach, and I suppose the government would have been sort of trying to continue down the same line for sake of sort of ease, but it's, you know, more fully recognised once you look into the evidence that actually we do need this different approach going forward, and for more you know, LPAs to sort of take that forward in the future, which is supported by the evidence when you look at the energy modelling. So yeah, it's progress.
I think ultimately, so we consider that we have evidence of this approach, and it is within our ability to seek to require this support, notwithstanding from that space.
Okay. What about Mr. Barrett's points about the delays that having these kind of locally distinct standards could result in? He mentioned, for example, that house builders would have to redesign their standard house types prior to submitting applications in Surrey Heath or other authorities that adopted this non-standard approach. And so that was one source of potential delay. And a second was about the potential gap in skills for people to verify whether these standards have been met. Reference was made to, for example, hitting those standards of airtightness. So what's the council's response to those points, please?
I think it again we are going in sort of the potential hypotheticals, and there's nothing for the sites in the local plan that we would consider this would cause a delay for. In many cases, there's it's more achievable on flatter development, which is a significant source of our supply in the town centre. And there are many changes that happen, biodiversity net gain, building regulations that change, and the system adapts to it. And some of those can be very local. In Surrey Heath, for example, the Thames Basin East Special Protection Area has a very significant impact on how development comes forward, but it hasn't caused a delay in housing coming forward. I know it's difficult when we can't rely on evidence that we feel our case is evidence and justified, and that's where we are.
Okay. Thank you. Mr. Barron, do you wish to come back?
I suppose turning to the last point in terms of the Thames Basin Heath, when Thames Basin Heath first came in, it had a significant impact on the ability of local authorities to deliver. I think wherever there is a significant change, there can be. You also have a look at in terms of building regulations. Building regulations are often phased in terms of coming in, so they're announced and then introduced. And I think so what we have in terms of the improvements we've seen to Part L of the building regulations is we had the 2021 changes were introduced. They didn't come into force until 2022 to allow developers to understand the impacts of that. And again, it's the same in terms of future home standard. There's a lot of work to ensure that we're moving forward. It's very different to a planning policy that comes in, and therefore you've got to deliver. So there isn't a phased introduction of what is a significantly higher standard to what developers are delivering at the moment. And I think those are the concerns we have, sir, is that there is a lack of understanding in terms of what it might mean in terms of delivery and in terms of the type of I think in terms of flatter development, the council are right in terms of it is easier to achieve in terms of flatter development, but this will apply to all development moving forward. But there will still need to be considerations as to how one meets how a development meets this standard, and whether actually that is something, you know, as a developer moving forward looking at a PDL site, whether that's something you can achieve in terms of that, and whether you want to bring that forward, or whether it's going to delay you looking at that site and wanting to bring that site forward. So I think those are concerns. In terms of looking at whether the energy use intensity and those aspects of the government did look at that in terms of building regulations and rejected that in terms of as an approach in favour of taking forward the home's energy model with regard to the assessment with regard to that. So recognising the issues with SAP. And not ignoring the issues with the SAP, the standard assessment procedure, procedure. I can't remember off the top of my head. So actually stands for, and recognising there needs to be change and introducing that change. So that change is happening through the building regulations. And I don't think what the council have done is they've looked at that, and I think this is the problem. They've looked at the overall arching viability. Viability it can deliver without looking at the aspects of deliverability alongside that. And in terms of those local authorities that have adopted, I've got to admit, Uttlesford, and I can clarify, sir, that they've gone through main modifications. The inspectors haven't suggested a change with regard to that. So, you know, clearly the inspectors at that felt it was evidence-based, but obviously every local plan needs to be looked at its own merits, and the evidence that's provided needs to be looked at its own merits in that case. But there's also a case in terms of the Isle of Wight, where it wasn't considered to be deliverable in terms of that. That was on the basis of viability or consistency with the written ministerial statement. So there's swings and roundabouts with regard to those plans that have been considered post written ministerial statement and how inspectors have responded to that.
Thank you, Mr. Byrne. Okay, I'll hear a final point from the council. I think I'm getting to the point where I've got all I need, but I'll hear a final point from the council on this before we close. Thank you.
So we feel we've put forward our case, and that we feel that it's a justified position. Appreciate the points that have been raised, but we don't have anything further to add unless there's anything you would like clarification on.
Not from my perspective. It's been a helpful exchange, and it's enabled me to understand the council's position and also Mr. Barrett's position. I don't think there's anything further I need to ask in terms of points of clarification. And I've probably got all I need to come to a view on the points that have been raised. Okay. With that said, we've concluded discussion under point 4. Which brings us to the end of today's hearing session. Apologies for the slightly rocky start to proceedings and my IT issues. There's always issues when things go virtually, and obviously the council, you know, press the wrong button. That's happened to me before, and personally I quite enjoyed seeing Mr. Slade's cat. That was a bit of light relief in the grand scheme of things. But such is the way things go on virtual hearing sessions. But thank you all for your patience, particularly this morning, and for your contributions. There aren't any more hearing sessions scheduled, so I think the next step from my perspective, I need to go away and digest what's been said today, and I'll be in touch with the council with regards to next steps in due course. Obviously, there's a lot for me to reflect on, but yeah, at this stage, thank you everyone for your contributions. Thank you to the council for all your input of the process. And yeah, like I say, I'll be in touch shortly and outlining next steps in at that point.
Thank you.
Thank you, Inspector.
Thank you, sir.
Okay. Okay, thanks everyone. Well, the hearing is then closed. Thank you all for contributions. Bye.
Thank you.
Thank you.